Good afternoon or good evening, depending on where you're joining from today. Thank you for joining our weekly podcast recording for Transformation Ground Control. Today's topic that we're going to cover is the legal side of digital transformations and ERP software. So we're going to talk about everything you need to know about the legal components of what to consider and what to keep in mind as you go through a digital transformation or an ERP implementation. My name is Eric Kimberling. I'm the CEO of Third Stage Consulting. We're an independent consulting firm that helps clients throughout the world with their digital transformation journeys, and we help them reach the third stage of digital transformation success. And I'm going to introduce our guest in just a moment. Since I'm not an attorney, I thought it might be good to have an attorney that actually knows the law to be on this stream. So we're gonna introduce him here in just a moment. But before I do, just a couple logistical things first. As I mentioned, this is a weekly live recording that we do every week. We stream to YouTube, LinkedIn, Facebook, and Twitter. And this live interview becomes part of our weekly Transformation Ground Control podcast, which we'll add content to this, we'll edit it, we'll polish it, all that good stuff. And then the full episode will come out a week from tomorrow, on Wednesday of next week. So every Wednesday we release new episodes of this show on the platforms I just mentioned, as well as audio podcast platforms throughout the world. Secondly, we're going to take audience questions. The whole reason we do this live interview format is to get audience questions. So I encourage you to please drop in the chat any questions you have along the way. If there's anything on your mind that we happen to be talking about, or if there's something legal that you have in mind that we're not talking about, I'd love to hear your questions. If you've got topics or questions for discussion, I'd love to hear them. And speaking of the chat, I'm going to be watching the chat throughout the entire conversation here today, so I can see the conversation on all the platforms here in front of me. And if you don't mind, just drop in the chat what city and country you're joining from today. It always helps to see where in the world everyone's joining from here today. We've got a global community we typically reach, so I'd love to hear what city and country you're in. Just drop in the chat. We'd love to hear from you. So again, today's topic, the legal side of digital transformations in ERP software. Joining me today is Marcus Harris, an attorney at Taft Law. And Marcus, this is not your first time here, but I think it's probably your fourth or fifth time on the podcast. So glad to have you again. Welcome to the show.
Hey, Eric, thanks for having me. I'm really excited to be back, and I'm really excited to do the digital stratosphere later this year. I think the topics that we're going to talk about certainly today are kind of a preview of what we're going to do later this year. And so, like I said, I'm excited to be here today and to talk to not only you, but field questions from the audience. You know, like I said, I'm an attorney here at Taft. Taft is a national law firm of about 850 lawyers with a very deep bench, and they're particularly deep. We are particularly deep in technology, intellectual property, patents, science-related issues. So, you know, we're well suited to talk about these things today, and I've got a lot of experience in this area, having worked in-house at a couple of large international software companies.
Yeah, and that's actually a great point. I'm glad you mentioned that. You have a unique perspective, having sort of worked both sides of the table. You sort of know the inner workings of software and technology companies, and obviously you represent your clients sometimes on the other side of the software companies. That's a pretty unique perspective that most don't have.
Yeah, that's absolutely right. You know, we'll represent large software vendors in multi-million-dollar transactions and generate contract templates for startup ERP vendors. We're doing that now. And then we also represent a variety of different size companies with their software acquisition, implementation. You know, we take them from 0 to 100 and provide, you know, whatever kind of comprehensive legal services they need, depending on the budget, which is often dictated by how much they're actually spending on the software product. You know, you approach something much differently if you're spending $100,000 versus 14 or 18 million dollars. It's a much different type of legal representation. One of the other things that we do, which I think adds a lot of perspective to this conversation in particular, in our representation in general, in the ERP space, and this is one of the ways we met, is that we litigate these issues and we deal with failed ERP implementations. Today, I say we probably do more on the client side as far as the representation is involved, representing clients that have been victimized by, you know, oversold, overhyped, not fully baked products. They got duped during the sales process by maybe overeager salespeople. And then we've also in the past represented a variety of different software vendors in connection with allegations of failed implementation and breach and fraud and negligent misrepresentation. And so that's a pretty well-rounded perspective to be able to talk about a variety of the nuances and the legal issues that come up in these deals.
Yeah, yeah, absolutely. So you've seen some pretty gnarly situations and gnarly legal contractual situations over the years, I imagine, which we'll kind of get into here today.
Yeah, absolutely.
So what is while I ask you this question, I'm actually going to pop on the screen a little some information about our upcoming Digital Stratosphere conference. It's October 4th through the 6th in Denver. You can go to stratosphere2023.com to learn more about this conference. But not only are you speaking at this conference, but Taft is also a co-sponsor along with Third Stage for this event, which we're really excited about. We were just talking before we went live how exciting it is to do an in-person event again after a few years of not having done it, at least in the case of Stratosphere. This is our first post-COVID in-person event. Really looking forward to it. And can you tell us a little bit about what you're going to be speaking about or what topic you'll be covering at Stratosphere?
Yeah, I mean, this year, I really want to get into the ins and outs of what the contract negotiation process is like with respect to a typical ERP project. When you engage attorneys, how often in the process, how to use attorneys to mitigate the likelihood that you're going to have problems, what the contract negotiation process looks like, what are some of the key issues in those contracts that you've got to really focus on to ensure that you're setting yourself up for success. I want to talk about how to mitigate failure, and then really what to do when you're faced with a problematic ERP implementation. What steps you need to take to try to get that thing back on track, and then from a collateral perspective, in really talking about some of the bigger issues in the contracts. I want to talk about certainly intellectual property, some of the substantive representations and warranties that you need to look for, and then I want to talk about the massive impact that AI and Chat GPT and platforms like that are having on the ERP space, and some of the unique challenges that those present from a contractual perspective. And
It looks like we lost Marcus. I thought it was just me, but we lost him. So his feed is frozen there. So I'll fill in for him until he's back. Hopefully he can get back on the stream here. And just drop in the chat if you don't mind, if you're having trouble seeing him too, or hearing him, or if it's just me. I think it's universal. So no, so I think one thing I'll talk about just while he's coming back on here, Marcus and I are both speakers that'll be presenting at Stratosphere 2023 here in Denver, Colorado. And we'll have about a dozen other speakers as well. So it's not just he and I, although I would say he and I could probably fill a full day's worth of content, but we will have about a dozen other speakers that'll cover different topics. And certainly Marcus will cover the legal aspects of transformation. And then I'll be covering a keynote during the session as well. In fact, I'll share with you what I'll be covering, or share a little bit more about part of what I'll be covering is actually a keynote based on my new book, which was just released this last weekend. So if you haven't already, you can scan the QR code here on the screen in front of you to order the book. It ships worldwide. You can get it electronically or in paperback or hardcover copy. My keynote at Stratosphere will dive into some of the major themes of the book and talking and focusing on primarily digital strategy. So be sure to check that out. And if you haven't already, I encourage you to buy the book. It's on the bestseller list in a few different categories. So I appreciate everyone who has bought it already. But if you haven't, you can get it here ASAP by ordering it since it's on sale now. So I'm going to stall a little bit while we're waiting for Marcus to come back on the stream here. But one of the things I'll sort of dive into and sort of set the stage while Marcus is rejoining here is that we're going to cover today a few different topics related to the legal side of transformation. Some of the things I had in mind, and I'd love to get the audience's feedback here as well. But some of the things I was going to talk about with Marcus and some of the questions I want to ask him are first of all, what some of the biggest challenges are from a legal perspective that he sees with digital transformations and his own client teams. What are some of the biggest struggles that they are struggling with? That's one of the things we want to cover here today with Marcus. And then another topic we're going to cover as well, we want to get into intellectual property too, which is a pretty big deal. I'm not an intellectual property expert by any means. I know it's not the sexiest thing to talk about, but it is really important as you think about digital transformation, especially in today's day and age of artificial intelligence and ChatGPT and whatnot. That creates a lot of challenges that organizations have to think about or they should be thinking about the intellectual property side of things. So we're going to talk about that. What is ChatGPT? What is custom ERP software or open source ERP software? What are some of the intellectual property considerations there? So all that being said, I just ran out of things to stall with, and it looks like you're back, Marcus. Can you hear us okay, Marcus? Okay, I see him but don't hear him, and I don't think he hears me either. So hopefully he'll be on audio here in just a second. It looks like it's a bad connection there. So just chime in whenever you can hear me, Marcus. Can you hear me now? I can hear sirens. Okay, he's not hearing me, but so that's one of the things we want to get to is intellectual
property. Hopefully you can hear
me.
I am back.
I can. Can you hear me? Okay, he's not hearing me. So we'll have to figure out a way to get the audio worked out there, Marcus. So the other thing we want to talk about
I got you now, so hopefully you can hear me.
Okay, you good?
I think so. Yeah.
Okay, good deal. There might be a little bit of a lag, but I'll pause in between questions here. But I guess just to start, Marcus, what are some of the biggest legal challenges that you see your clients struggling with at the moment?
Well, look, in the context of an ERP project or an ERP implementation, I think one of the biggest issues that we see on a pretty regular basis is the continued push for this cloud migration. And I think certainly cloud makes sense, and it's really a direction that I think if it makes sense for your company, it's something that you need to seriously consider doing. But I also don't think you need to throw the bait, meaning really that, if you've got an on-premise solution that really works for you, and that's a delivery model or a usage model that is something that you can still utilize, you don't necessarily need to fix it if it isn't broken. And I say that for a variety of reasons. One, I think that there is a perception that really is perpetuated by software vendors that these cloud contracts are low risk, that they need to be consistent, that they need to be the same across the customer base, and they do that so that they don't have to negotiate them. And so there's a huge level of inflexibility, not with all vendors, but certainly a large subset of vendors, as to the terms and conditions that they will actually be willing to change. And the rationale and reason they have for pushing back is, look, this is a standardized offering across our customer base, and the contract needs to be consistent for everybody. And if we had to do this for you, or if we have to do this for you, then we would have to do it for everybody, and we just can't do that. And that, to me, is really an untenable position, because what it leads to is you signing a contract that is less than favorable, that in some ways might shift all of the risk of that legal or business transaction to you from a legal perspective. So you have unlimited liability. The vendor has no liability to you. You're not only are you shifted, the risk is being shifted to you from a legal perspective, but from a business perspective, you're contractually obligated for the success of the project, and that doesn't make any sense. Why are you hiring them? What's the purpose of you engaging with them if you're the one responsible for the success of the entire project? One of the other things that we see, and this is troubling as well, is the wholesale incorporation of URLs into these documents. So what you get forwarded to you via DocuSign is a 2-page order form that looks pretty innocuous. In reality, there's about 10 to 15 URLs that each link to a 15-page terms and conditions document that can be updated or modified at any point during your contractual relationship with this vendor. And that is just crazy to me. Okay. And to really do this right, you've got to focus on the contract as a whole, including all the URLs that they stuff in there and try to hide from you. So I mean that all of that is a huge issue on the ERP front, just from a practical side.
Yeah, those are great points, and I guess coming back to the first point you made about the fact that software vendors create these standard one size fits all contracts so they don't have to negotiate. If let's say I'm a CIO at a $100 million U.S. turnover or an annual revenue sort of a company, $100 million in revenue. I'm a CIO or an IT director, and I'm dealing with SAP or Oracle, a company that has tens of billions in revenue and just massive company compared to me as my organization. What sort of leverage do I have to change that? You know what I mean? Because we get a lot of clients that say we're a tiny fish in the sea, in a big pond or a big sea. Can we really push back on some of these terms and conditions? And what's your experience been?
I mean, that back probably 5 years ago, I would have said you've got a lot of leverage, and you're going to have a lot of success getting normal concessions that are reasonable and mitigate the risk of that transaction. I would have said that you've got a pretty good chance of doing that if you're spending any reasonable amount of money. Today, I think you've got to spend an insane amount of money. You got to be in the multi-millions in order to really have a lot of push and leverage with certain vendors. And so what your strategy needs to be, and be clear, I am specifically talking about the software side of this transaction, not the implementation side yet.
Right.
Okay. And so if you are not spending serious money with this vendor, there's going to be no incentive for them to get off their standard positions. And their standard positions are absolutely horrible. Okay. And so what you need to do is make a list, have an attorney or your in-house people go through that contract and identify, the top 5, top 10 things that are the most important to you, or the riskiest, really. And importance and risk are kind of two sides of the same coin. And once you have done that, you can kind of assign a risk rating to them and figure out, okay, if I don't get all 10, which you're probably not going to get, what can I really live with, and what do I really need to push for? You've got to break them down into business issues and legal issues. And the business issues always drive the legal issues. And we like to say, well, all issues are really business issues, but pure, business issues, what kind of warranty you're getting? What's the limitation of liability? Is there an indemnity obligation? What are they stepping up to as far as reps and warranties and that kind of thing? And make sure that they're substantive and real, because what you want is, if it all goes sideways and you've got to litigate this contract, you at least want to have a dog in the fight.
Right.
And you get there by having, subjected them to, a reasonable limitation of liability so you can recover money damages if you need to, so that they'll do something. They have an incentive to fix something. There's a warranty, and it's got substantive remedies if there's a breach of that warranty. You want to make sure you've got things like that. You've got an indemnity obligation so that if the software causes an issue for you and you get sued by a third party, they will do something about it, and you're not left holding the bag. So, really the way to mitigate that is to pick the big top 5, top 7, top 10, whatever it is.
Yeah, you may not get everything you want, but if you get the top 5 or however many, high priority showstoppers, that's a pretty big deal.
Yeah, I mean, and it's not about nuance depending on the vendor and the size of the transaction. It's really just that it's what can we get? What's going to make this an easier transaction for us?
Right.
If you're in a specialized industry like banking or finance or whatever it is, that you've got specific requirements, that might be a different situation, and you may have some more pull there.
Right. So here's a really interesting question from Rahendra on LinkedIn. Rahendra says, Marcus, what percentage of customers hire legal experts before signing contracts with ERP vendors? Do you have a sense of that?
It's hard to say. Not enough of them, to be quite honest with you. There's an old saying in my industry that early legal advice is not expensive.
Right.
And if you spend, I don't know, the legal spend has to be proportional to what the business deal size is. But let's say you spend 5% or 10% of the deal size on a legal review of the contract, you're going to put yourself in a much better position as if you didn't, because God forbid you've got to enforce that contract in some way. You never negotiated it. You're not going to have any success.
Right.
That contract, every paragraph, every comma, every sentence is going to be against you, and you're going to have a pretty hard time. We see on a pretty regular basis contracts that come across our desks where there's a failure or some other sort of breach, and you look at this and it's like, well, you spent $5 million. Did you have anybody look at the contract? No, we didn't. I mean, to me, that's just insane. I mean,
Yeah,
the
it
risk
is.
is there. Why not mitigate it?
Right. Well, in your internal legal counsel, if you have that, if you're a big enough company to where you have an internal, general counsel or a legal team, that helps, but they generally don't negotiate these kind of contracts every day like you do. So I think that's one of the big things that companies overlook too, is they look at it from a pure T's and C's perspective, and they probably, your internal legal counsel can presumably help with a lot of that, but there's a lot of nuances that are unique to the industry and a lot of gotchas and pitfalls that you wouldn't know just from being an attorney. You would know from being an attorney that does this all the time. And I think that's a nuance that a lot of organizations miss out on too.
Yeah, I couldn't agree more. I mean, I think any attorney that looks at a commercial contract is going to be able to look at, 3 or 4 issues and understand that doesn't seem reasonable. But, the great challenge with agreements, is particularly in this industry, is, is what is there reasonable? Is it market, so to speak? That's not something that you're going to know if you don't do this all the time. And then the other thing that you're not going to know, which is equally as important, is it's easy to see what's in the contract and tell a client it's reasonable or unreasonable, or it's risky or not risky. But what about the things that are supposed to be there that are not? And if you have no experience in this area, you're not going to even be able to key in on those issues. And that, to me, is worth the price that you're going to pay for an attorney review.
Yeah. And when you're dealing with these big software companies too, and the big technical consulting firms, the big system integrators, when you're dealing with those really big companies, we're sort of circling around this topic of leverage too. We haven't used that exact word yet, but one thing you have to look at is what kind of leverage do I have with a big, massive behemoth in the tech industry? And part of it is the knowledge that, someone like Taft or you, Marcus, could bring to the table. But there's also a leverage that comes with that too, that I think is really important. And it comes from hiring companies like Third Stage too. Even though we're not attorneys, we're not here to negotiate contracts, but we do provide, part of the reason why clients hire us throughout their digital transformation is to help provide leverage, to where they have ownership and leverage over the project and over their partners. And sometimes you hate to think that way. You don't want to think adversarially, but when you're dealing with a two-sided contract, or you hope it's two-sided, it may be a one-sided contract, which is even worse, which is sort of what you're alluding to here. You need that leverage and that negotiation leverage. I've seen it with you, where a client hires you, and it's not just the knowledge you bring; it's the fact that you have an attorney from the outside that's helping you, and that changes the dynamics of the relationship and the conversation in general.
Well, it really does. And I mean, I think one of the other tips here is you need to hire experts. Okay. If you don't have the in-house expertise, and the life cycle of these products is pretty long, right? And maybe in your career, if you're at the same company, you do this maybe 2 or 3 times in your career, right? Maybe if you've jumped around companies, you've done it 5, 6, 7 times. But having said that, I mean, you may have some understanding of how these things go as an individual professional, but hiring attorneys and hiring consultants that can develop RFPs, RFIs, conduct software demos, develop scripts, all of that stuff is incredibly important for you to get an understanding of what you're about to get into, mitigate the risk associated with it, and really someone that can benchmark what you should be doing against what other people or other companies your size are doing. That's invaluable information. And then once you've got that empowerment, it gives you realistic expectations as to how that negotiation process is going to go, what you can expect to get or not get, and from a bigger picture, what the implementation process is going to be like, how much is it going to cost, and how long it's going to take. I mean, you've got to have all that information going into this, and the only way to get that oftentimes is by hiring somebody that's done it hundreds, if not thousands of times.
Right. Yeah, exactly. And here's an interesting follow-up to a point you made earlier, and this is also from Rahendra on LinkedIn. And Rahendra says, Marcus, URLs and contract that you mentioned is interesting. Could the customer not insist that documents in URLs need to be printed and signed as part of the contract?
Yeah, I mean, and that's really kind of the way to get through it, right? Is to say, look, you can't give me a moving target of a contract, and I need to have some guarantee that you can't unilaterally change the what I think are agreed upon terms. And so let's attach all these URLs to the agreement as exhibits. That's certainly the way to do it. The challenge that you're going to run into is this whole flexibility argument. And they're going to say, well, that's all well and good, and we're willing to do that. But you have to understand that as the product set changes or we improve and provide additional functionality, the requirements or the descriptions or the specifications are going to change, and those documents that are at URLs necessarily will need to change as well. And so you've got to account for that, which in some ways is a reasonable issue that they have, but you've got to make sure that they don't take unfairly advantage of it, or unfair advantage of it, excuse me.
Yeah, absolutely. Here's a question from Kyler on LinkedIn, a really good question that's very pertinent in today's day and age. When moving to a cloud solution from an on-prem solution, legacy system, what are some of the key nuances you should look for in the contract, such as total cost of ownership?
Well, it's a good question, and it's nuanced. I think there's a lot of ways to go with that, but certainly from a legal perspective, you want to make sure that you're getting some sort of a discounted rate. Okay, the rate or the discount is going to be proportional, I think, to the length of the term. And having said that, there's going to be a resistance on the part of the vendor to give you the ability to easily get out of that contract without having to pay. So if you've negotiated a really good deal and you've got a 5-year term, they're not going to want to let you get out of the contract for convenience after year 2 without having to pay the remainder of the term. So the total cost of ownership in that context is going to be much higher than an on-prem model, arguably. And there's a lot of nuance and gray area to what I just said, and we can get into that. But the reality of this total cost of ownership is that the cloud model is not necessarily cheaper. And in fact, I would assert that it's probably more expensive. And one of the reasons that drives the push to the cloud and the transition from everybody, going from on-prem to cloud, is it's a revenue grab in some respects, and you've got to be careful with that.
Yeah. I was actually talking to a vendor, one of the bigger software vendors in the space last week, and they were the first vendor I've ever heard admit that cloud is better for them than it is for their customers. And it's not anything I think they'd say on record. They would never say that on this live stream or in this format, but they were saying, I wasn't even baiting them into saying that. I wasn't, because usually that's something I would say, or you would say, but they kind of came out and said, yeah, the cloud thing it's great for us, but we don't necessarily know that it's best for all of our customers.
Yeah, there's a lot of disadvantages to it. I think cost is only one. The flexibility and the ability to customize the software certainly isn't as robust as it would be in an on-prem solution. So, and that's what I said earlier is, the push and the drive to the cloud, you got to be careful with that. Sometimes it doesn't make sense for you, and just because everybody else is doing it doesn't necessarily mean you should do it too.
Yeah, absolutely. Now this is great because I love all these audience questions because it's taking pressure off me to ask you questions. It's the bad news is it's just putting pressure on you, Marcus, to answer more questions, but it's taking it off me because I don't have to come up with questions. But this is from Ryan on LinkedIn. He says, have you started to see any issues arise from companies leveraging artificial intelligence or machine learning in their implementations? And what do those issues look like? So I feel like this is not a can of worms, but a Pandora's box that we could spend the entire hour talking about if we wanted to. But what are some of the big things you've noticed here?
Yeah, and this is a huge issue, and I'll try to kind of hit on some of the highlights. Look, AI is certainly the wave of the future, and I think there's a lot of implications for ERP, and I think some of them are certainly amazing. And it runs the gamut from AI generated code in the development process. So you've got a vendor that's using artificial intelligence to streamline the development of the code and the implementation so that you're paying less money overall. You've got, robust artificial intelligence tools built into your ERP system that, are going to be more efficient or allow you to be more efficient, predict things, use your data in ways that you can only imagine. And all of this is amazing stuff. But from a risk perspective, you've really got to be open and aware of a variety of issues. From an intellectual property standpoint, really there's a ton of issues here where, what and it comes down to the corpus of data that AI is trained on. Okay, so what AI tool is being used either to develop the software during the implementation process or to integrate it, or what AI tools have been integrated into the ERP system that you're going to use on a going forward basis. Now, you've got to know that because you have to understand how that artificial intelligence system or platform was trained. What data or corpus of data is what we call it, was it trained on? What you don't want is, to be utilizing a system that has just gone out on the internet and collected all sorts of data and is now incorporating your data into that corpus. And that data set is also available to all of your competitors because you're on the cloud and you're sharing an AI platform. Samsung, not that long ago, had a huge issue from a trade secret perspective where their internal employees were putting in secret information into an AI platform that was publicly available, to do something with getting more efficient in their work stream, I suppose. And no one knows exactly what happened to that trade secret information. Now it's been incorporated into that AI data set, and now other companies are training on that, or other companies are using data that's been trained on that data. So, there's a variety of issues here, and I think the bright line rule is make sure that you really need to use AI. Okay, and if your vendors are using it to develop deliverables, code, integrate your software, know what tools they're using, know what the terms and conditions associated with it are. Okay, and then you also need to have an understanding of what AI tools are being incorporated into your ERP software that you're going to be using on a going forward basis. And the reason for that is you want to understand what happens to your data once you put it in the AI system. You want to have an understanding of what you can do with the data that comes out of that AI system. If it's 10% your info and 90% your competitor's info, and they still have an ownership interest in it, and now you incorporate it with your deliverables or your products, and then you go commercialize it, what are the issues associated with infringement? So there's just a ton of kind of mind-blowing issues that you really have to consider. But I do think it all comes back to having an understanding of the tool sets and the terms and conditions that are governing those, and doing a level of due diligence to understand what the risk is.
Right. Now, you were on our podcast a couple months ago, and we talked specifically in that episode about artificial intelligence, OpenAI in particular, ChatGPT
Right.
and OpenAI. And I guess just to ask you a question or a topic we touched on in that, I think it's worth bringing up again here today. But if I'm using ChatGPT, and let's just say I'm on a digital transformation project team, or let's just say I'm not even on a project team, I'm just part of an organization, and I'm using ChatGPT to create some graphs or do some analysis for me using my company data. What happens to that information? Who owns it? Do I have protection? Is it out in the public now? Like, what do I need to be aware of, either as part of a transformation or an organization in general, if I'm using ChatGPT or OpenAI tools like that are so common now?
Well, if you were incorporating data from your company, okay, you're putting it into OpenAI or ChatGPT, you want to have an understanding of what happens to that data once it's put into that platform. And there's some platforms where you give up ownership interests in it, and or you give a perpetual license to the platform so that it can incorporate that information into the data set, train on the data set, and then spit out additional information for other users and that information is based on or somehow reliant upon the information that you put in previously. Okay, so there's a variety of litigation right now, and one of them deals with Getty Images, where the AI system was trained on publicly available information. Okay, and some of those are just Getty Images that are out on the internet, and you ask a OpenAI platform to generate pictures of cats or something, right? And all of a sudden, it's a conglomeration of different Getty Images, and the Getty image watermark is on there. That is problematic, especially if you're going to go use that and or worse, commercially exploit that and do something with it. Getty Images is going to come after you and say, hey, that's my information. You've built derivative works based on that information, and now you're commercially exploiting it. You owe me a lot of money. So that's that's the scenario that you have to be aware of and worried about. You're putting your company information into the OpenAI platform to generate graphs. Now, what are you going to do with those graphs? Do you have the right to utilize them? And if you give them to your client or your customer and they go do things with them, what's the risk to them?
Yeah.
None of this is really settled. You've got to look at the terms and conditions of use of that OpenAI platform to make have an understanding of what the risk is.
So if I go out to ChatGPT right now, let's just say hypothetically, I were to say, I asked ChatGPT to, I'll give you an example. We use HubSpot for our CRM system.
Right.
And HubSpot has like this integration now to ChatGPT and OpenAI, where you could I could type something into HubSpot, which is where we track all of our client information as well as our prospective client information. All the leads that come in on our website, everything goes through HubSpot. If I were to go to ChatGPT using that integration with HubSpot, and I say, run a report of the last, or tell me who the last 100 leads were that came in through our website, and it spits out a report for me, or it gives me some sort of consolidation or summary. Is that information now sort of public domain? Like, in other words, do I lose the sensitivity or the confidentiality of that information that I had housed internally? Now I've used OpenAI to do some sort of analysis or do something with that data. What happens to that information?
Well, there's a huge risk. So if you were going to then argue that information is a trade secret, okay, and you had put that into ChatGPT or HubSpot or whatever it is, and there's an express license from you to that platform allowing them to utilize that information, create derivative works, and provide it to other people, the argument that you are going to make that that's a trade secret is out the window, basically, because now you've negated any trade secret protection that you might have otherwise had for that particular information. So if you have anything that's secret, confidential, or sensitive, it should not be put into an OpenAI platform. It just shouldn't.
Right.
There's a tremendous amount of risk. Now, the way to get around this, and a lot of the vendors are developing their own systems, is you want to have an OpenAI platform that is closed, I would say, and it's being trained on your own data. And so what's coming out of that system is something that's been vetted by your own company and utilized can be utilized with some assurance that you're not giving up secrets and you're not infringing. So for example, one of the practical impacts for a law firm would be, we've negotiated thousands of enterprise software contracts, okay? And we've got an employee, a first or second year attorney, that is tasked with coming up with a contractual framework for a brand new ERP vendor or startup, and he doesn't know where to start. He goes into our version of ChatGPT or whatever, OpenAI platform that we've developed, but the data set, the corpus of data is documents that attorneys at this law firm have developed in the past. They've all been reviewed. They're reviewed on a consistent basis, and they're all good, solid documents to use. And now he can be confident that, the documents that he's generating based on those aren't going to be infringing. They're not going to include any client secret information, and he's not giving up any kind of intellectual property that he shouldn't be. That's where you want to get at some point. And there's a whole continuum between 100% safe utilization of OpenAI versus a totally risky one, and you kind of want to be somewhere in the middle.
Right. Yeah, that makes total sense. Here's a follow-up on LinkedIn that I think is super interesting. Be curious to get your reaction. Lots of companies are coming up with OpenAI-based products in manufacturing lines, smart cities, et cetera, you name it. How can we use it to our own advantage without much risk to client data? So in other words, how can we leverage AI in these open models, but also not run into the problems that you're talking about?
Yeah, I don't know if you can, to be quite honest with you. I think it's an inherently risky thing to do, and you have to understand the risk. And I sound like a broken record to some extent because I keep saying go back to the terms and conditions. But if you're utilizing a particular AI platform you have to read what they can do with your data and what they can't do with your data. It's a pretty simple exercise. Print out the terms of service or the terms of use, which is a binding contractual agreement, and understand what guarantees are they making to you and what are you giving them. Oftentimes, you're giving them an irrevocable perpetual license to utilize the data that you put in there in any way, shape, or form that they want, and they use it to train their AI system. And it's available then to other customers that are using the AI platform as well. And so the way to mitigate it is either don't use it, which isn't a good solution because everybody's going to use it. Develop your own system, or license it on a exclusive or semi-exclusive basis where you've got terms that are more favorable to you than to the general public. There's tiers, right? You go to Chat GPT, you've got a free service, you've got one that you can pay for. That's once you start paying for things, then you can customize the level of risk and what you want to agree to and not agree to. You might customize some of the benefits and the functionality as well, though.
Yeah, that's a great point. And as we were talking about this, and as that question came out, I never thought of this before until just now. And this is stick with me for a moment. I'm going to go conspiracy theory for a second. But the Great Reset, the line of thought that there's a movement to sort of equalizing countries and people within countries and sort of knocking down barriers and competitive advantages and things like that. I'm oversimplifying what the Great Reset conspiracy theory is, but it makes me wonder now if OpenAI is part of that Great Reset conspiracy. That could be a whole nother topic.
You never know. I mean, you remember, Snowden, I guess is how you say it, when he disclosed all the national secret information, and there were the USB thumb drives that actually were distributed to all these adversarial countries that infected their computers and was a tool for spying. I mean, who knows? I mean, it very well could be something like that. You got to be careful.
Well, and even if that's not the intent, there's not some conspiracy behind the scenes happening. I mean, you do have to be aware that from what you're saying, it sounds like you could lose a lot of competitive advantage by giving up some of this confidential information and advantages that you have as an organization. And so just being aware of it, I think, is step number one. And then you also mentioned in that episode you were on last, I think you were talking about getting policies in place. You talked a bit about, what you can do to mitigate and to sort of, especially now that ChatGPT, I keep talking about ChatGPT, even though that's only one part of OpenAI or one example, but that seems to be the consumer facing one that a lot of people know of, and they can use it at home and in their personal lives or at work. But you get a lot of people that start using ChatGPT or OpenAI in the workplace. You sort of have to put some parameters in place of what can or can't you use, in terms of confidential information within that open source model.
I think it's critical. I mean, if you're a company of any size, doing any kind of reasonable amount of business, and you're trying to use these tools, you've got to put some sort of policy in place. You've got to put guardrails for your employees to have an understanding of when they can and when they can't utilize it. Because if there is an incident, you want to insulate yourself as much as possible from liability. If you have no policy and it's the Wild West, you've got to help you, right? I mean, I think you're really setting yourself up for some potential liability there. But I think if you have a well thought out internal policy as to when people can use it, what they can use it for, and what they can't put in there, then I think you're doing about everything you can do to really mitigate the risk to your company and the liability that would follow.
Yeah, absolutely. Great points there. Are there any other sorts of intellectual property types of risk? And that's essentially what we're talking about here is confidential data and intellectual property and how do you protect it? And we've been talking about it a lot in the context of OpenAI, but what about custom software? If you do customization to software, I'll give you an example. We have a client right now who's doing an SAP implementation, and they're sort of co-innovating with SAP for a certain industry that they're in to create a product that fits their industry, which is highly risky, by the way, but that's a whole nother conversation. Highly risky to co-develop this stuff and then introduce it to your organization when it's never been used by anyone else. That's a whole nother story for another time. But what about intellectual property in that case when you customize software? Like, who owns that in that case? If your software vendor is creating customization for you, but you're paying for it and you're using it for your organization.
Well, most customers think that because they're paying for it, they own it. And that's not the way the law works, unfortunately. So the way the law works is the ownership defaults to the author, and software code is authored in this context. So in the context that you just laid out, SAP would be the absolute owner of it. And now that becomes problematic for a variety of reasons. And one is, if you're developing something or paying SAP to develop something for you that is strategic and gives you a strategic advantage, you're going to want to have some exclusivity associated with that competitive advantage. And you're not going to want SAP to have an ownership interest in it. And so that needs to be detailed in the contract. I think, one of the ways, and SAP does this in particular, to deal with this situation is to clarify, hey, look, everything that we, SAP, bring to the table, our pre-existing intellectual property, will remain ours, okay? Everything that is your pre-existing intellectual property is going to remain yours. And then anything that we do on the project specifically for you, that's where the gray area is. SAP's default position is we own it and it's ours, okay? Mm-hmm. And their rationale for that is, well, we're a software development company, so to speak, and we need to take that piece of deliverable technology, whatever it is, code that we're developing for your particular implementation, and then be able to utilize it across our customer base so that we can gain efficiencies for that. And that's our business model. That's what we do. Your argument and counter to that is, well, I'm paying you specifically to do something that I've come up with that is innovative, and I need to own it. And so those are the two, loggerheads that you're going to run into. And, you've got to put contractual language in the agreement. It's called work for hire language specifically that would vest ownership in anything that's custom created in your company. And, whether they're likely to do that or not depends on a variety of factors, including how much money you're spending. But, one of the interesting questions is, what if SAP is developing something for you? They're going to own that because it's based on their code, but it incorporates a piece of, technology or information or confidential information, whatever it is, and that's embedded in it. Who owns that embedded piece of technology or information? That's something that you've got to carve out contractually and make sure everybody understands.
Yeah. Well, of course, there's you've addressed the legal side of it, and then there's the ethical side of, should a software vendor be charging a customer to develop software that they don't have? So in other words, you're hiring an ERP vendor or a commercial off-the-shelf software vendor to provide capabilities out of the box that, that's the whole point of it. Otherwise, you could go create your own custom software, and maintain that competitive advantage.
Right.
But there's the ethics of software vendor charges for it, develops it for you, but they take that and then that becomes sort of the industry standard that they provide to other customers, their own customers that are presumably competitors of yours, by the way. If you're the one co-innovating with them, right, there's nothing stopping that vendor from now offering that same capability to other vendors.
And they will do it, right? If they've got the ability to do it, they're going to do it. And they're going to be laughing all the way to the bank. Their position would be, well, look, everybody thinks that they've got something innovative and amazing, and really all this stuff is the same from customer to customer. No one's really doing anything that much differently anyway. And so there's no ethical issue here. It's an issue of practicality. And if you were to have an ownership interest in this as a customer, then if we were to ever provide something that's substantively similar to other customers, you're going to be able to sue not only us, but those customers. And that creates an untenable situation for us. So, this is one of the most negotiated, difficult issues in these kinds of agreements. But I think you're right. It's not only an ethical issue, but it's also a practical one too. Why are you hiring SAP to custom develop software for you for something that should be off the shelf? You've already got a problem, in my view.
Yeah.
And you're headed down a road that's ripe with difficulty, whether it's spending way too much money, going over budget, having issues with support and maintenance for customized software that nobody else has. There's a lot of issues there.
Yeah. Well, and just as a footnote or kind of what happened next to that client example I gave you, and since I didn't mention the client, I can say this. And by the way, it's not the only client we have that this has happened to, but they canceled their S/4HANA implementation.
Oh, wow.
And they're trying to do this co-innovation thing. And when you hear the word co-innovation, this is not legal advice. This is just more third-party consulting advice. But when you hear the word co-innovation, that's usually code for we don't have the functionality you need, so pay us to develop it for you. And you have to really that's highly risky. I mean, you might as well at that point go create your own custom software, because that is what you're doing. It's actually in some ways even worse, because you're taking a off-the-shelf system and you're trying to change it to do something it wasn't designed to do, but you're changing it for your business. And that's always risky to do.
I think you hit the nail on the head. I mean, it is risky. Why would you do that? I mean, you're creating just a whole risk profile that subjects you to a lot of problems, and it doesn't make a lot of sense to me.
Yeah. Now, what are some of the ways, if we sort of tie this all together, if I'm on a project team and I'm about to go through a transformation, I'm about to go procure software, what are some of the best ways to mitigate risk during the procurement process? What are some of the low-hanging fruits that you would recommend?
Yeah, and look, I mean, this is going to sound, like a sponsored kind of statement or something, but to hire somebody like you, to be quite honest with you, but what you want is, consultants that have an understanding of the software evaluation and selection process. And I think if you're in that procurement space or phase, those are the types of consultants that are going to provide the most value in selecting, the right solution for you, vetting that out, pitting vendors against each other. I mean, what you want are, tight RFPs, tight RFIs that actually, help you. You want to be able to, select vendors based on objective criteria, which would be software demonstrations, testing, scripts, that kind of thing. Get an understanding of the total cost of ownership, the cost of the integration, the implementation, any customization that would be necessary. And then, keep two to three vendors, in that selection process while you go through that contract negotiation, so that you can see what are you actually getting, who's giving you a better deal. Let them know that they're competing against each other. I think the worst thing you can do is, look at what your competitors are or who they're using, pick that company, move forward with it, and just sign a contract as is with them. That to me is just a recipe for disaster in a very big way.
Mm-hmm. Yeah, but yet a lot of companies do that. Exactly that.
Yeah, and those are the companies that you see fail, and they wonder why they're in this situation where they're over budget, milestones have been missed, and they're not getting the functionality or the business benefits that they wanted to realize. And there's a reason for that. You didn't do your homework on the front end, and you're not going to get it on the back end.
Right. Yeah, exactly. Now, what about during implementation? What are some of the best ways to mitigate risk during the legal risk during the implementation process?
Yeah, I go back to these contractual tools, right? And there's an old joke: if you hire a carpenter to do something, he just wants to hit everything with a hammer, right?
Right.
And that's kind of the lawyer's perspective as well. But here, I think it's really true. I mean, you have to negotiate solid implementation-related contracts that serve as a tool to manage and govern your relationship with that vendor throughout the process. Okay, you want to be able to pull out a statement of work and say, this is when you were supposed to do this. You didn't do it. Here's what you have to do now. And here's the impact on the budget. That to me is tight governance of the project. And it has to be in the contracts, because if it's not, you're relying on them to develop a project plan. You're relying on regular meetings. You're relying on project status updates that may not really provide you with any substantive information anyway. Those can be manipulated, and the true health of the project can be hidden from you. I mean, you've got to put contracts with teeth in them, to manage the project. They're going to push back, of course, right? They're going to say, well, we've got this vague implementation methodology, and you just need to trust it, and that this is how we do things. They won't provide you with any kind of timelines or estimations or milestones or deliverable deadlines, and just say, well, here's this vague PowerPoint presentation of how an implementation normally goes. Good luck. That's
Right.
the opposite of what you want. But the reality is, I mean, today, with the push to the cloud, standardization among vendors, the argument that the contracts are all standard and the implementation should be standard too, you're going to run into a lot of pushback on this. And agile software development is a problem as well, where they're going to say, well, we can't do it that way because we just got to iterate, and that's the value of our system, and it's a lot more beneficial to you in the long run. Well, that's not really true in my view. I think they're telling you a load of BS in order to get you to sign on the dotted line, and then they're going to do what they want, and,
Right.
and they're going to charge you for the benefit of them doing what they want.
Right. Yeah, exactly. Yeah, the agile conversation is a whole nother Pandora's box. We could spend an hour on that for sure.
Yeah, I mean, that's the bane of a software attorney's existence is, having an agile methodology, and then they come back and say, well, we can't even have SOWs because, it's just you just got to iterate the whole time. And that's just a horrible, horrible strategy.
Yeah. And you hate to say it, but you look at what are the ways that software vendors and implementers protect themselves. And you talked about the contractual protection, the one-sided contractual protection they put in these one-size-fits-all contracts that are meant to serve their self-interest. But then agile too, that's another thing that regardless of whether or not it's the right answer for a client, it is a good way to protect yourself if you're an implementer, because you're just adapting, you're reacting, it takes away the need, or it takes the pressure off you defining requirements up front and having a clear strategy and blueprint for how you're going to deploy technology. It takes a lot of that pressure off you because you're doing it in the name of agile.
Right, and you're doing it on an hourly basis. And, you can just you're getting drunk off hourly charges or hourly fees. Like a pirate on the dock, swigging rum, and you're just having a good old time. And
it's a great analogy.
All to agile, and you're making a ton of money, and it's not going anywhere. There's no checks and balances on your performance, and all that's obviously risky.
Now, anytime I see a technical consultant, I'm going to think of he or she is a pirate on a ship just drinking rum. So Pirates of the Caribbean or whatever.
That's right. That's right.
Well, good. Well, I really appreciate your time here today, Marcus. This is a great overview, and as always, a good conversation. And time flies when we're diving into this stuff. So really appreciate you being here today.
Oh, absolutely. I just looked at the clock. I didn't realize that our time was up. I apologize for having technical difficulties earlier. I'm not sure what happened, but we were able to get back into it pretty quickly. So
hey, it worked out all right, and you forced me to tap dance a little bit and stall, which is always a good way to get. I'm not a morning person, so it's a good way to wake me up. Just to keep me on my game here.
Well, I see you drinking those monsters in the morning, so hopefully that's giving you a lot of energy.
Yeah, exactly. Yeah, I should try and get them as a sponsor of this podcast, because I'm usually drinking a monster on camera here. But I also want to leave the audience with this. If you'd like to meet Marcus and I in person, along with about a dozen other thought leaders in the industry, technology agnostic people that can provide some good guidance and lessons from digital transformations, be sure to attend the conference and join us in Denver, October 4th through the 6th. It's called Digital Stratosphere. It's a technology agnostic conference we host. Used to be every year in person until COVID happened, and now this is our first time back in person. You can register. You can look at the agenda, which continues to change and evolve because we're continuing to add to it. We're taking an agile approach to our agenda development for the event, but partly because we continue to add new speakers and new sessions. But join us. You can learn from people like us. Just as importantly, the peer networking is a really powerful component of this event too. So you can go to stratosphere2023.com. I'll be doing a book signing there for my new book that just came out. Marcus will be there presenting as a keynote. I'll be presenting as will others. We'll even have live entertainment. There'll be an 80s tribute or 80s cover band, which is really good. They're an amazing band. I've seen several times. It's actually my favorite 80s cover band. So you can you'll get to enjoy that as well if you join us. So we'd love to meet you in person so you can learn more. You can register. You can see the agenda at stratosphere2023.com. And Marcus, thank you for co-sponsoring that with us. It's co-sponsored by Taft, by us, as well as Technology Evaluation Centers and a company called Avero Advisors. The four of us, the four companies, are co-sponsoring that event. So thank you for being part of that, Marcus.
Yeah, absolutely. It's a great event. I am looking forward to it. I invite all of you people to come. It's really a pretty valuable event and a unique event like none of the other events that I attend or speak at. And there's a lot of interaction between the attendees and the speakers and the sponsors, and so I think you get a lot of value add out of this one.
Absolutely, yeah. It's you've been there a few times, so you can speak from experience of what a great event it is, and you've been a part of it. Every time we've done it, in fact, Taft has co-sponsored it, so we appreciate your partnership there, and look
Absolutely.
forward to doing it again with you, and look forward to seeing all of you there, all of you listening here today. So thank you again for joining us today, Marcus. Thank you to the audience for the great questions. Again, this interview will become part of the Transformation Ground Control podcast that gets released a week from tomorrow. So Wednesday of next week, every Wednesday, you can find new episodes of Transformation Ground Control on audio podcast platforms, wherever you listen, or it streams to LinkedIn, YouTube, Facebook, and Twitter as well. So be sure to check it out wherever you prefer. Hope you all have a great week. In the meantime, we'll look forward to seeing you next time on the Transformation Ground Control live recording. Have a great week in the meantime, and we will see you soon.
All right. Thanks, guys. Appreciate it. Bye-bye.